Fox News alert on the hunt for fugitive NSA leaker Edward Snowden. Witnesses say that Snowden never got on that flight that he was expected to be on out of Moscow, heading to Cuba. But when the U.S. does eventually track down Snowden, what kind of legal ramifications is he facing? Judge Andrew Napolitano, Fox News senior judicial analyst, joins me now. Boy. So he's had a curious trail so far, and we don't know where he is right now. We believe he's in Moscow
and
still.
It's becoming curiouser and curiouser by the countries to which he's, as KT just discussed with Bill, as the countries to which he's chosen to go and what he might be doing while he's in those countries. I think he's just trying to avoid prosecution in the United States of America. Others think he may be doing other things to harm us while we're there. I mean, who knows? We'll find out if and when he's caught and if and when there is a trial.
All right, so let's say he is caught and he's brought back here. He's been charged with espionage.
Yes.
How does that charge hold up based on what he's done?
Espionage is constitutionally questionable, I'll tell you why in a minute, and practically difficult for the government. It's constitutionally questionable because the Espionage Act of 1917, this is a World War I, quote, temporary law just to get us through World War I, which punishes speech that can harm the government, has arguably been overruled by the Pentagon Papers case. Whether it's been overruled or not, a court's going to have to decide. He will be the first person to have been charged with espionage since that case. The other practical problem with espionage is, in order for the government to prove its case, it has to prove that the defendant's words harmed the government. In the act of doing that, it often has to reveal more secrets than the defendant revealed, which is why these are very, very unusual prosecutions. The Pentagon Papers case opinion and the difficulty of proving espionage, however, does not relieve him of the charges of handing over classified materials to an unauthorized person. That is a charge that will stand and one that he'll have to answer for.
You know, when you think back to what we talked about last week with regard to whether or not this program really kept America safe, when you look at the 50 examples that were put forward by General Alexander, and he's, laying out the case that, I mean, you have to prove that in order to prove that espionage was committed, right? That what he revealed actually made us more vulnerable because the program was indeed working.
Yes, and I don't know that the government wants to do that. I mean, since General Alexander's revelations of last week, the NSA has pulled back on one of its major arguments, a case in which it turned out there was no jury trial and the guilty plea had nothing to do with what they found from the surveillance.
The stock exchange situation.
Snowden wants to be able to make a moral argument that he had two oaths with which to comply, his oath to keep secrets and his oath to support, protect, and defend the Constitution, and they were incompatible, and he opted for the higher oath. I don't know if the court will let him make that argument. If the court does let him make that argument, then we're in an area that's away from the law and into value judgments, and what kind of value judgments can people make when they decide how to comport their lives. He will say, I revealed the greatest violation of Fourth Amendment rights by the federal government in the history of the country. The public has the right to know that the government is listening to all of its phone calls and capturing its emails.
Well, what a lot of people say, if he feels so strongly about it, there's no place better to make his case as a whistleblower than here in the United States of America. All right, we are back. There is a lot going on this morning, and we have just received a decision from on the affirmative action case from the Supreme Court. This has been a huge case, Fisher versus the University of Texas, which we've been watching throughout the course of this. Judge Napolitano is with me to sort of get our arms around this a little bit. We know it was a 7-1 decision. Elena Kagan recused herself in this case, and the premise here is whether or not this young student, this woman, was rejected from the university because she was white. She claims that minority students who took advantage of affirmative action and were lesser qualified were accepted over her.
The big picture here is whether or not the Supreme Court is going to reverse a series of opinions from 2005 involving the University of Michigan, also a state school like the University of Texas, which went in the direction of the school and permitted the school to use race as a basis for decision making. Look, it's been argued for 100 years that since the Civil War, race has been removed as an armament from the quiver of all government. It can't make decisions based on race. University of Michigan cases, opinions written by Justice O'Connor said you can use race, but only for the next 25 years. No one knows where she got the 25 years from. Now comes this plaintiff named Fisher in Texas saying, forget the 25 years. It's 10 years later. I lost this slot because I'm white. What kind of a 14th Amendment enforcement is this? Today, to the chagrin of everybody involved, people who wanted her to win, people who wanted the state to prevail, the Supreme Court basically punted, sent it back to the lower court and said, well, read between the lines here. You know, those University of Michigan cases, maybe we're going to change them, maybe not, but give this woman her say. Let a jury decide whether or not Texas discriminated on the basis of race. Texas admits it discriminated on the basis of race. There's nothing for the jury to decide.
And Shannon pointed out that the process is that the top 10% of students are accepted to the university, a state university, and then after that, when they're deciding who gets those slots, they do take affirmative action into account and try to create a diverse student population. But it raises this large issue of the time frame and of the last 100 years and whether or not we should be in a position now to not have a box that's checked off with regard to race, that people would be judged on the merits of their academic success.
That wonderful legal scholar who's seated on the other side of me used that, Bill Hemmer used that great technical term, punt.
Yeah.
That's exactly what the Supreme Court did today. They didn't gratify either side, nor did they clarify the law. But they basically said, start the trial over again, bring it back to us in a couple of years.
The decision was written by Justice Kennedy, so we're going to start digging into that. We'll get more on it as we weed through all of this. Thank you so much.
Double
duty for Judge Napolitano.
Pleasure
Thanks for being here, Judge. Good to have you as always.
It doesn't look like the voting rights decision or the gay marriage decision comes down today, apparently, according to SCOTUS.
Well, they have to give us something to talk about the rest of the week.
We'll make something up. Thank you, Judge.
Earlier this month, Fox News senior judicial analyst Judge Napolitano appeared on this program and said that Ed Snowden is a hero because he exposed details of these surveillance programs.
I would describe this man as an American hero, as a person willing to risk life, limb, and liberty in order to expose to the American people one of the most extraordinary violations of American principles, value judgments, and the Constitution itself in all of our history.
Well, since that appearance, Ed Snowden leaked other information, details about America's secret spy operations against foreign governments, various foreign governments. So does the judge still think of Ed Snowden as an American hero, now that he seems to be working with countries including China, Russia, Cuba, and Ecuador? Judge Napolitano was with us. What about it?
I'm smiling because obviously heroes can be flawed. The only hero that wasn't flawed was killed on Good Friday. His act of exposing the American government spying on almost every American was an act of heroism. What he has done since then might not be what I would have done, but that particular act was an act of American heroism, which was lawful because of his oath to uphold the Constitution. I'm glad that he did it, because the American public is entitled to know when the popularly elected government is doing the opposite of what it has sworn to do: uphold the Constitution and preserve our freedoms.
Of course, there are now suggestions that Ed Snowden may have taken that job as a contractor so that he could find out this information, so that he could then leak it. Others have suggested, including Gordon Chang, that he might well be working with the Chinese against the Americans.
You know, no one knows where this is going to end up. Espionage is a very problematic charge for the government to bring. I'm surprised they brought it.
Political.
Sure. The statute, the Espionage Act of 1917, Shep, was a temporary World War I statute that was supposed to last only during World War I. Here we are nearly 100 years later. And it prohibits speech that encourages the enemy or discourages Americans from resisting the enemy. It was arguably invalidated by the Supreme Court in the Pentagon Papers opinion. It's also difficult to prove espionage because in order to prove how your spying apparatus was harmed by what this former spy did, you have to demonstrate to a jury what your spying apparatus is, and the government may end up revealing even more secrets than Mr. Snowden did, in which case we would then say, well, then where's the harm if the government's willing to spill the beans in order to get this guy? On the other hand, it is clear, because he's admitted this, he did give classified information to people who were unauthorized to receive it. Was he morally justified in doing so? A jury will probably decide that. I would think a jury in the United States would treat him better than a jury anywhere else.
That'd be my guess. All right, Judge, thank you.
You're welcome, Shep.
Now, like many others across the country, I am deeply disappointed with the court's decision in this matter. This decision represents a serious setback for voting rights and has the potential to negatively affect millions of Americans across the country.
Joining me now, Judge Andrew Napolitano. He's our Fox News senior judicial analyst. So, Judge, in terms the folks can understand, explain what the High Court did today.
The High Court starts with the proposition in the Constitution that the states have retained for themselves the power to regulate their elections. It's not a power that they gave away to the federal government when the federal government was formed. The High Court recognizes that throughout our history, many states, particularly in the South, abused that authority by making it difficult and in some cases impossible for people of color to vote.
Because just to jump in, back in the day when discrimination was just everywhere and accepted in many corners, they would say, okay, yeah, blacks can vote, but they have to pass this little test before they can vote. And then they'd create some ridiculous test that effectively deprived black voters of their constitutional rights. Hence the Voting Rights Act, which said, you can't do that, and if you try to mess with the voting laws in your state, you have to get approval first from the federal government, and that worked over the decades to equal things out to a large extent.
Yes, the statute actually created the presumption that any regulation enacted by the South or by many counties in many of the states in the South that had the negative impact on the ability of people of color to vote was presumed unconstitutional. Therefore, it could not become the law until it was approved by bureaucrats in the Justice Department. And quite frankly, the Supreme Court said nice things that procedure actually worked. It worked so well that, according to the court, the procedure is not necessary anymore because the conditions that caused Congress to create that procedure have been eradicated by the procedure. And so now, where we don't have the rampant discrimination, the absurd questions put to black people intended to prevent them from voting, it's not necessary for government officials in the South, when they're redistricting, for example, to get the approval of people in the Justice Department first. They can just go ahead and enact the laws, and then if someone's offended by it, of course they can challenge it.
And the High Court was never taking away or going to even consider taking away someone's right to sue if a state or a local municipality behaves badly. You can still sue and say, you did do the ridiculous test. I object, it's discriminatory, and you can bring that lawsuit. This is all about whether the feds have control over states and local governments before it ever gets started. You can't even pass a law on voting rights without Eric Holder saying it's okay. But now, and to speak to your example, the High Court in its opinion spoke specifically of Alabama. In Alabama, they said white registration back in 1965 was 69%, black 19%. So there was a problem. Today, well, they went to 2004, 74% white, 73% black, which is why you had Chief Justice John Roberts in the majority opinion saying, why would we be subjecting Alabama automatically to pre-clearance from Eric Holder when it wants to change its voting rights laws?
You know, there's another interesting, quirky aspect to this, Megan, and that is the court does not like statutes that regulate some states differently than others, because each state is sovereign. And the court really struggles when the Congress enacts legislation that doesn't apply to all 50 states or to everybody in the country. And only when a state really, really misbehaves and makes it so obvious that they can't be trusted with the authority they retained under the Constitution can the Congress single them out for specific regulation.
Now, I want to ask you this, because already you heard the negative reaction from Eric Holder. President Obama had a similarly negative reaction. The left has already been very upset. In her dissent, Justice Ginsburg called this hubris by the majority, and we're going to hear a lot today from folks who don't like this decision about how it's a major setback for civil rights, for voting rights. Your take on those reactions?
My take is that it would have been a major setback had this been invalidated in 1965 when it was enacted. But nobody is seriously complaining today. At least I haven't heard it. And you and I watch these things and look for them as it's part of our job here, Megan. Nobody is complaining today that there is systematic efforts on the part of the government in the South to keep people of color from voting. So I think those who are unhappy with this today are unhappy with the loss of the symbol. The reality is that anybody who wants to vote can vote, and that's the way it should be.
Yeah, and they've kicked it back to Congress to come up. They haven't said you can never require pre-clearance. They've just said, Congress, if you're going to require that of somebody, you need to make a showing as to why the state really has to meet your requirements. You have to take a modern-day look at each person or state you're going to regulate. And Congress has been loath to do that because it's a politically charged issue.
Right.
But now they have to.
You can't rely on data that's 60 years old.
Yeah. Judge, good to see you. Thank you, sir.
Pleasure.
Okay, breaking news from the U.S. Supreme Court. Right before the break, we got the decision 5-4 ruling. The Defense of Marriage Act has been struck down. Now, there's some nuance to this that I'll get to in a moment, but standing by with me, Brett Baer on the politics of this, Shannon Bream on the steps of the U.S. Supreme Court with the decision in hand, and Judge Anna Napolitano with me in studio here in New York. Judge, to you. This is a decision that applies to states that have already recognized gay marriage. Now, what does it say about a gay couple who could be married in, say, the state of New York, but moves to the state of Texas? What does Texas do with that relationship?
Texas is free to reject the same-sex relationship that was made in New York and the couple moved to Texas. But the federal government is not free to reject it. So you could have a couple lawfully married, a same-sex couple lawfully married in the state of New York, moving to Texas. The state of Texas will not recognize that marriage, but the federal government will. Not all of DOMA has been struck down by the Supreme Court today because not all of DOMA was challenged in this case before the court. The court can only strike down the portions of the statute that have been challenged. The only part that was challenged and struck down is whether the federal government can declare that marriages must be opposite sex, and the Supreme Court said it cannot. So the issue of whether a state, and I'm not picking on Texas, I'm just using it as an example,
correct,
whether a state like Texas can reject a same-sex marriage lawful in a state like New York has not been resolved by this case. So the law this morning on that was Texas could reject it, and the law after this case stays the same. Texas can reject it.
Meaning if Texas had benefits that could go toward a couple that was lawfully married,
Texas would not have to afford them to a same-sex couple living in Texas.
but the federal benefits would still apply.
Precisely.
Thank you, Judge.
Well, look, the issue is, can the government defend a statute? And if the government chooses not to defend a statute, does that mean that the statute is indefensible or illegitimate, or the lawyers who are in the courtroom don't have the right to be there? They were willing to overlook that issue in DOMA. We don't know if they overlooked that issue. It appears they didn't in the Proposition 8. We'll hear about it as soon as Shannon can finish reading what the runners have just sent to her.
All right, you got a judge. And first, the judge on the split of justices.
The decision today, Bill, is not on the merits of same-sex marriage. The decision today is not on whether or not California can authorize same-sex marriage. The decision today is not on whether or not the people can undo something that their state Supreme Court did. The decision today is whether or not people who don't have a real interest in the outcome of this can file an appeal in a federal court, what lawyers call standing. Standing is the doorway to the federal court. If you don't have the right to be there, then no matter how meritorious your claim is, the court is not going to hear the case. That's the technical legal argument. The practical effect of what was done today in this California case is to leave the trial court's decision as the law in California. And as Shannon just so ably described, that decision says the Supreme Court of California had the right to declare same-sex marriage as a valid fundamental liberty from the Constitution of the state. Therefore, same-sex marriage is lawful in the state of California, notwithstanding a majority of the voters attempting to make it unlawful.
Would you expect another legal challenge in California on that ruling?
I don't think so. I think, as you pointed out a few minutes ago, Bill, once the state and the apparatus of the state is in favor of same-sex marriage, remember Governor Brown refused to send state lawyers into court to be involved in this case. The apparatus of the state will begin, I think, very soon to process applications for same-sex marriage in the largest state in the union.
All right, they got it. You pay for it. Within minutes of the Supreme Court deciding that gay couples are indeed entitled to the same benefits as heterosexual couples, companies are scrambling to figure out how much it's going to cost them to comply. To the judge who's been crunching the numbers, crunch away, Judge. How much?
All right, so if it is a benefit from the federal government, even if it's a same-sex marriage in a state that doesn't recognize it, you're married in New York, you move to Texas, one of the spouses retires, is that spouse, and the other spouse dies, is there a survivor benefit under Social Security? Answer, yes. It doesn't matter what state you're in. Now suppose you're married in New Hampshire, in New York, and move to Texas, and you work for a corporation that does business in Texas and in New York. Does that corporation have to give spousal benefits, even though the state of Texas does not recognize it? Court didn't rule on that today, but the rule of thumb is if the corporation does any business with the federal government or receives any benefit from the federal government, it then must treat its employees the way the federal government treats its employees. So just because a state does not recognize same-sex marriages does not mean that corporations doing business in that state are free from any additional financial burden as a result of the invalidation of Section 3 of DOMA today.
Now, what a lot of companies might decide is, for the better part of the argument in valor, we're just going to go ahead and provide these benefits, right?
I think that's coming. And if you listened to David Boies, who represented the plaintiffs in these cases, speak outside the Supreme Court, they're going to use language from the Supreme Court's decision in DOMA, which talks about how marriage is a fundamental liberty and how it's really none of the government's business who you choose as a mate, to try and persuade courts in the states that don't recognize same-sex marriages to force corporations that do business there into providing benefits as if the states did recognize
But don't the
same-sex
vast majority of companies, gosh, I would imagine all in one way, shape, or form, stand to do or will do business with the United States government. And by definition, they have to adhere to this.
Yes.
So by that, it's a big victory for gays.
It's a big victory for gays. It's a big victory for the spouse of the married gay partner. I think that you're going to see a lot of corporations just throwing up the towel and saying, we're going to treat same-sex marriages as we do heterosexual marriages.
A lot of them already do.
Yes, they do. Our own does.
Our own, and was a lead player in that.
Yes.
But so this notion that many in the business community were saying this is going to be very costly, and all, a lot of them are already doing it, right?
The large corporations, the Fortune 500 corporations, no, the medium or small are not doing it because they'll feel the increase. But the large are doing it in part because their competition is doing it. So there's a competition for the best workers. They don't want this issue of, will my spouse get benefits, to stop a talented person from being hired there. I don't know that the court thought about this, but in fairness to the court, these financial issues were not before it. The only issues that were before it today were the constitutional ones. Can the federal government give a benefit to a heterosexual couple and deny it to a same-sex couple? The answer after today clearly, unequivocally, is no. Benefit to one, benefit to the other.
But anytime there's an interpretation that one has gotten special treatment of the other, the lawsuits are coming.
Yes. Yes, the lawsuits are coming. Places like Texas, where same-sex marriage is not only not recognized, it's unlawful, that is going to be challenged by the same people that prevailed in the Supreme Court today.
Judge, you've been a tour de force today, young man.
Business for lawyers, as Stuart Varney would say.
Yes. Well, he just loves anything that could help capitalism. He doesn't even care what benefits. But
God bless him.
Thank you very much. Judge, you had to see him on FNC when this broke, and then on FBN. He popped up on Nat Geo. It was amazing.
I didn't see myself on Nat Geo.
Yeah, it was funny. And then, on Speed, you're on that. Hard to run around.
I respectfully decline to answer any questions and invoke my Fifth Amendment privilege to remain silent.
Another IRS official, Greg Roseman, refusing to answer questions about allegedly helping a friend win $500 million in agency contracts. So is there any way to make employees tell us what they know? Let's ask Fox News senior judicial analyst, Judge Andrew Napolitano. Hi, Judge.
Hello. Good morning.
Great to see you. So can people just plead the Fifth in front of a congressional panel forever?
Well, generally, yes, but remember, this is an employee-employer relationship. So let's start with a normal employer-employer relationship. Let's say that our boss, Mr. Ailes, wants to ask you questions about work that you did here, and you attempt to plead the Fifth.
That doesn't work?
No, that doesn't work. He can fire you because he and Fox News are not regulated or controlled by the Fifth Amendment. The Fifth Amendment only controls the government. It controls the government, but also as employer.
So in other words, everything that Greg Roseman and Lois Lerner have done thus far, that's legal, that's totally within bounds.
They cannot be fired for refusing to answer questions put to them by their employer, whether it's somebody who runs the IRS or whether it's an investigator from the Congress, because she's protected both as an employee by the Fifth Amendment.
Okay, so then how do congressional investigators ever get to the bottom?
All they have to do is get the Congress to vote her, Lois Lerner, or this fellow that we just showed, or whoever they believe has the most information that can lead them to others, that can tell them what happened. vote that person immunity. Once you are voted immunity, then you don't have the right to claim the Fifth Amendment. And then you are required to answer, and if you don't answer, a judge will put you in jail until you do answer.
But if
and
you
can be fired for not answering.
Okay, so if you give that person immunity in order to get more information, then you can't prosecute that person.
You can't prosecute that person on the basis of the information that person gives you. You could prosecute that person on any other independent evidence you generate about that person. But Allison, as a lot of people watching us now know, law enforcement does this all the time. There's 10 people involved in a bank robbery. They catch one of them. They cut a deal with that person. He squeals on the other 9. Basically, that's what you're going to have to do here with the IRS.
All right, we'll see if that's the next chapter.
Otherwise, we are going to be watching all summer while the people that we have given the power to take our property away from us in order to fund the government refuse to tell us how they did it.
That's a different soap opera than the one I like. This one's called As the Stomach Turns.
You look like you've been spending more time in the sun at the beach than watching soap operas.
You make a good point. Thanks, Judge.
Pleasure,
Great to see you.
Allison.